In the absence of a definition held within the Copyright Act 1969, the term dramatic works has been highly contested between litigants. The central question to be answered is what exactly constitutes a dramatic work in order to afford it protection under the Act. This has previously been very difficult for parties to establish due to its intangible nature and the construction of the legislative provisions themselves. Section 10(1) of the Copyright Act goes as far as stating what it does include, which is a choreographic show or other dumb show, and a scenario or script for a film, but that doesn't include a film as distinct from that scenario or script. Two cases have shed some light on the judicial interpretation of the term dramatic works for the purposes of copyright law. The first case being Green and Broadcasting Corporation of New Zealand, which arose whereby the plaintiff Green, the creator of a British television talent show titled Opportunity Knocks, claimed that his title, show format, and various stock phrases were deemed to be a literary or dramatic work for the purposes of the Act, and therefore protected by copyright. Justice Summers found that the scripts could not constitute dramatic work, as they could not themselves be acted or performed. His Honour took this to be the essence of such a work, and the scripts were no more than a general scheme for a proposed entertainment. The actual telecast program, however, to which each script was the general guide, may have been a dramatic work. However, this wasn't claimed by the appellant, nor was it suggested that any one of his many telecast productions was actually copied. His Honour went on to state that situations or scenic effects by themselves, apart from the words and incidents of a dramatic work, cannot be the subject of dramatic copyright, referring to the case of Tate and Fulbrook, 1908. It should be noted that in 1989 the words described in writing in the form in which the show is to be presented were deleted from the definition of dramatic work held within the Copyright Act of 1905. This was to ensure that choreography will be protected if recorded in some material form other than note-taking, for instance, on film. In the case of 9 Network Australia Pty Ltd and Australian Broadcasting Corporation 1999, the court was required to consider the extent of exclusive rights granted to a broadcaster in return for payment to the organisers of the public event. The plaintiff had contributed $450,000 to the cost of a New Year's Eve event to take place at the Sydney Harbour precinct. The plaintiff attempted to restrain the defendant from broadcasting in Australia anything featuring the fireworks, procession of lanterns on Sydney Harbour, and decorations on the Harbour Bridge. The judge noted that the question to be answered was whether the setting off of the fireworks spectacle is a dramatic work in the ordinary sense of those words. It was ultimately determined by Justice Hill that the schedule of the fireworks display would not be deemed to be a dramatic work for the purposes of the Act, as it was too difficult to determine whether the reduction to a material form would in practice be adhered to according to the planned sequence. His Honour notably stated that at page 338 of the judgment, at the heart of the problem may well be that copyright is a monopolistic right existing not to protect ideas as such, but the physical manifestation of work. It's clear from these two judgments that in order to fall within the scope of dramatic work for the purposes of the respective Copyright Acts, required some degree of tangible certain form. Distinct detail must be established to ensure that the work is capable of being identified for ownership, and this often is most easily achieved in script or written form. Thank you for listening.